This is the case of the state of Ohio versus Brandon Reefers, case number 24, CR 42165. Present before the court is Mr. Reefers, right?
Mr. Reefers, Your Honor. Brandon Reefers, appearing pro se, generally, not for the record, Your Honor, appearing generally. Sorry, appearing special,
okay.
Not generally, for the record.
All right, and we have Mr. Elter as standby counsel. We have Ms. Hyatt from the prosecutor's office and Officer Torek from probation. We are here today for sentencing. Mr. Reefers, did you have a chance to look at the PSI?
I'm sorry, sir.
Did you have a chance to look at the PSI?
I don't know what that is, Your Honor.
You know, I didn't think about this until just now because usually it doesn't come up. Mr. Elter, did you have a chance to look at the pre-sentence investigation?
I spoke with probation regarding that, Your Honor, and gave some of the recommendations that he was thinking of.
Okay. Where is it? Oh, okay. So, Mr. Reefers, we're going to let you read the PSI and then let Ms. Kuroko know when you're ready. I apologize that we should have gotten you that in advance. You're not allowed to retain a copy of it, but you can. Other than that, housekeeping matters, we have 1 day of jail time credit, and we have this is a mandatory community control case, right? We're all in agreement?
Yes.
And state opposition on the return of the firearms.
Your Honor, I'm assuming the defendant's going to be sentenced to community control, in which case he's not allowed to own or have access to firearms while he's on community control. So we would object to that until at least his community control until it's been terminated.
Is that a standard rule of probation, or is that?
Yes, Your Honor, it is a standard rule that clients under supervision are not permitted to own, purchase, possess, or use firearms, deadly weapons, ammunition, or dangerous ordnance.
All right. Mr. Reefers, do you want to go ahead and talk about the return of the firearms now, or?
I was going over the pre-sentence investigation.
Let's just take a break and let him go over the PSI.
Thank you, Your Honor.
Just let Ms. Kuroko know when you're ready. Thank you. All right, we'll take a break. Sorry about. All right, we're back on the record in Mr. Reefer's case. Has everybody had the opportunity to review the PSI?
Yes.
Yes, Your Honor.
All right. Any corrections, issues, anything additional from the PSI?
There's a few things in there that I don't necessarily agree with, but just for skimming purposes, it's fine in their report.
Okay. All right. We have 1 day of jail time credit. We started to talk about the firearms. Mr. Reefers, what about that?
Your Honor, I think my paperwork kind of stands for itself. I would like the firearms to be returned. I have a statement, if it may, whenever the time's allotted.
I mean, we have two separate issues. We have the issue of the ownership of the firearms. You are entitled to the return of your firearms. So I'm going to grant the motion for you to return, for the firearms to be returned to you. We have a secondary issue as to whether or not you were allowed to have those firearms while you're on probation. We'll talk about that separate issue in a minute. All right, as a preliminary matter, we have the renewal of the motions to dismiss, the motion for acquittal. Court's already ruled on those, but I am going to deny the renewal of the motion to dismiss and the renewed motion for acquittal. Ms. Hyatt, on behalf of the state.
Your Honor, my understanding, I believe the recommendation, it is mandatory community control. You're talking about sentencing now, I'm assuming? Okay. We are asking, I believe the recommendation is community service, and as well as we're asking for corrective thinking. I'm trying to think of something that would maybe be beneficial for the defendant. But on the more punitive side, we are asking for some local time. He only has 1 day of jail time credit. So we're asking for at least 60 days local to be served. I don't know if he has a job. I don't know if you want to grant work release, but I just feel like some incarceration based on what his actions were that evening that the jury found him guilty of warrant that.
Officer Tork, anything from probation?
Nothing further.
Mr. Reefers?
Is now the time to make a statement, Your Honor?
Now's the time.
Well, Your Honor, this case began with one simple question. What are you stopping me for? I asked that calmly and never received an answer. From that moment forward, everything that followed spiraled because that one question was never answered. The record shows clearly, at 3 minutes and 2 seconds into the traffic stop, I stepped out of my vehicle and shut the door. By 3 minutes and 8 seconds, the deputy grabs my right arm. By 3 minutes 12 seconds, he radios one resistant. By 3:14, by his own sworn testimony, that's when he considered me under arrest. In those 12 seconds, I was never told the reason for the stop, never advised I was detained, and never told what was being investigated. The prosecution even asked the deputy on the stand, "Did you tell him what the reason for the stop was before you cuffed him?" He answered no. Even afterwards, when I asked, "What did I obstruct?" he said I prolonged his investigation. When I asked, "Did you tell me what you were investigating?" he admitted, not at that moment, no. That's not lawful procedure. From there, I was tased twice. Then while standing, facing away with my hands up, he struck me with his ass baton. After I was cuffed, Deputy Simpson took my state trooper badge and credentials and put them in as evidence of guilt. What did that prove? That I know the law? That I served honorably? That act alone shows exactly how this case has been handled, by punishing knowledge instead of respecting it. At the jail, I requested a chemical test on camera, and the deputy refused. That denial is now part of the record. The jail intake video and audit logs from 1:30 to 4 a.m., which would verify that very request, are still missing. Civil counsel tried to quash the subpoenas, and this court denied that motion on September 8th. Yet those materials still haven't been produced. The record remains incomplete. In the crash report that supposedly justified the stop, there's no photos. One witness said white vehicle, another said black. The reporting deputy simply chose one color with no supporting evidence. No citation was ever issued. Even my address and driver's license number are wrong. That report isn't proof. It's an error sheet. So, Your Honor, I ask plainly, how can anyone be sentenced on a record this incomplete? Built on missing footage, contradictory witness accounts, and deputy's own admission that he never gave a lawful reason for the stop. I have met every obligation placed upon me. I have stood here in good faith, followed every order of this court, and done so with respect. All I ask in return is the same. Renew the motion, dismiss the case, or order a new trial, because this isn't about delay or defiance. It's about accountability. It's about an officer who abused his authority, answered a lawful question with force, and a citizen still standing before this court believing it will do what is right. May God's will be done. Thank you, Your Honor.
So here's the thing, Mr. Reefers. Your entire presentation is based on a flawed premise. And that flawed premise is that if you're pulled over by a police officer, he or she has to answer your question about why it is that you were stopped. That is not the law. It is not the law in the state of Ohio. It is not the law in the United States of America. The Terry v. Ohio, which is the quintessential case that involves investigatory stops, says you don't have to tell a person why they have been detained. That's the whole basis of an investigatory stop. I think that you know this, Mr. Reefers. I don't know, but I think that you do. In Ohio, case law is a little more nuanced, but it's still clear. Your question, why did you stop me, does not demand an answer. And your behavior following your not getting an answer was terrible. And first of all, with regard to the record being incomplete, this is the most complete record I have ever had in a criminal trial in the 20 years that I have been a judge. There is no stone that has been unturned in this case. There is no document that is out there that you have not had access to. Every piece of footage that we could find, some stuff wasn't saved, but also I would note that the jury agreed with you, Mr. Reefers, that the fact that you weren't given a chemical test or that you demanded one, all of the intoxication elements of this case were not considered by the jury, that you weren't found guilty of those. Everything that the jury found you guilty on is evident on that video, and your behavior should have been different. And I don't know whether or not you would have put up with the nonsense that you received when you were a law enforcement officer, and you just don't have the right to demand those sorts of explanations. and this is about your behavior, Mr. Reefers, you needed to be tased. You needed to be restrained because you were out of control. And it is apparent to me, having watched that video a couple of times, that you are the one that escalated this, not the deputy. And had you done the things that you were supposed to do, which is remain compliant and remain safe, none of this would have happened. You wouldn't have been found guilty of the obstruction. You wouldn't have been found guilty of the resisting. And this is on you. It is a mandatory community control case, so I am going to place you into my community control program. I'm going to do that I'm going to do that on non-reporting probation for a period of 1 year. Because I don't think that I need to put that much work into you, Mr. Reefers. I think that you have generally had a law-abiding life, and I expect that to continue. I know that there was some discussion that you might go to Kentucky. You and Officer Torak need to have a discussion about that, because we have to transfer your supervision, even if it's non-reporting probation, to a different state. They don't have to honor our parts of the supervision. So I can put you on non-reporting probation, and I don't know a lot about ICOTS, but I do know this part. I could transfer your supervision down to Kentucky. They're going to make the decisions. They could make you report every week. They could make you drug tests. I don't have the ability to tell them how to supervise you. Usually it happens in reverse, that we send them a case and say, hey, this person needs more supervision. And they're like, no, we don't care about your Ohio case. But that's something that you need to discuss with Officer Torak if you're going to relocate outside the state of Ohio. If you're going to remain in the state of Ohio, then that's going to be your supervision requirement. In terms of special rules of probation or standard rules of probation, I want probation rule number 1, that you're going to obey the law. Probation rule number 2, that you're going to keep your officer informed about your residence. Number 3, that you are not to leave the state of Ohio without the permission of your officer. Number 5, that you are to obey all lawful orders given to you by your probation officer. And 8, that you are to report your arrest. The rest of the standard rules of probation, I don't want him on, because I don't want to put a lot of work into Mr. Reefers. It is a special term of your probation, Mr. Reefers, that you serve a term of jail of 90 days. I'm going to give you credit for the 1 day that you have already done. That means that you still owe me 89 days of jail. I will make you eligible for the litter pickup program. So if you want to go pick up trash on the crew, you can do that. You get credit against your jail days. You get an additional day of credit for every day that you pick up litter. So over the course of the 90 days, if you go out on the litter crew 20 days, you're going to get out 20 days sooner. I'm not going to impose a fine. I am going to impose the costs upon you. And we have the issue, there is no restitution, right? He owes a ton of money to community corrections for the monitor, but that's just one of those things. It's not a term of your probation that you are not to have firearms in your house. So as far as I'm concerned, when you are released from jail, you can go pick up your firearms, and I'll do an order that says that you can get them. So we have a couple of issues. Well, first of all, if you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 12 months in prison, plus an optional period of post-release control of up to 2 years. That means if you violate, and if I send you to prison, the adult parole authority can, but is not required to supervise you for up to 2 years after your release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, those will all be provided to you at no charge. One of the things that you talked about in your filings, Mr. Reefers, was the fact that you are indigent. There's different tests for being indigent, and you sort of represented to me, I've never made a finding that you were indigent in this case because you were represented by Mr. Adams, who was retained counsel. When I appoint a standby counsel, I don't care whether you're indigent or not because it's not based on your inability to pay. But I assume that you're going to exercise your right to appeal. Am I right in that assumption?
Yes, Your Honor.
All right. Do you want to be appointed an attorney for the purposes of your appeal?
Yes, Your Honor. I requested to have the court appoint an appellate counsel on this.
Okay. Is it, I mean, this is not a standby, I mean, this is you wanting to be represented by an attorney for the appeal, right?
Yes, Your Honor.
All right. Are you working? Do you have a job? What's,
No, Your Honor, this has been my job doing this, and that's the part that I guess I'm not clear on. You said the record is accurate, but I don't have returned subpoenas yet. In the crash report, with all the errors that it has, I don't have a complete record. I don't even have the original request that Paul Sarver read from the stand from November 24th, 25th area, that the court said would provide me a copy of that. I haven't been provided any of that yet.
all right. Ms. Carrilco is going to give you the affidavit of indigency, which I know the black box one. Yes, that one. So that you can fill that out. And Mr. Elter, I think, is it okay? Would you be kind enough to go ahead and file the notice of appeal?
Sure.
That way, Mr. Reefers, you have 30 days from the date of the judgment entry of sentence to file an appeal as a matter of right. That judgment entry of sentence is going to be filed today. I don't want there to be any issues with the notice of appeal getting filed. So Mr. Elter is going to file that notice of appeal for you. He's not going to be your lawyer for the purposes of the appeal, although I guess he could. I don't know if you do that sort of work or want to be appointed. That's sort of a secondary issue.
I've done appeals, Your Honor.
Do you want to be appointed for the purposes of the appeal? Because you're the standby counsel, there's no ineffective assistance of counsel argument that can be made. I don't care. It doesn't matter to me. Why don't you talk to Ms. Idle? Because I don't even think we do the appointment of that. So talk to Ms. Idle and she'll see. Mr. Reefers, do you have a position in that?
I'm actually curious on the transcripts, because the record itself is what contains the officer's statements where he testified he didn't give me any lawful reason of what he was doing or detaining me before force was used. It's the premise of the stop. I simply asked what was going on, and that's when he escalated.
All right. So as part of the transcript, once you are found to be indigent, which is going to happen today, and once the notice of appeal is filed, which is going to happen in the next couple of days, then Ms. Kilgore is going to start working on the transcript, and then you'll get a copy of the complete transcript of the proceedings. The other stuff we've already covered ad nauseum. I'm not going to go into that again. But
Will that be all transcripts?
yes, she will prepare a transcript of all of the pretrial hearings and all of the trial. Okay?
Thank you.
All right. I am going to remand you to the custody of the county sheriff, and good luck to you, Mr. Reefers.